Good day and welcome to another episode of Strictly Legal on WESN Content Capital. I am your host, Rondell Donawa, attorney at law, and I'm excited once again to bring the law and you right here at Content Capital. You can, of course, stream us at WESN CC on all platforms. Now, let's get right into it. Of course, we know about judicial review. Many persons will hear that topic and will want to know what is really judicial review. As we know, it is an action against the state. But do you really understand as a citizen how it affects you, the law and you? Now, I have a guest today who will simplify to you, the viewers, all that you need to know about the instant topic and why the rule of law matters. His name is Kiel Taklalsingh. You may have seen his name many times in the media. He's an attorney at law of sovereign chambers. He has developed his expertise in public law and constitutional law, which is part of public law. He's passionate about the role of judicial review in upholding and maintaining the rule of law, and he's enthusiastic to help others. He has been involved in several prominent cases, and we will speak about that shortly. So I will welcome my guest today. Kiel, how are you?
I'm
You don't mind
well.
if I call you Kiel,
Of course not, Ronald. Thanks a lot for having me on the show. I'm a big fan. I'm a little nervous to be here, even more nervous than when I attend court. But
but you usually have your programming too. So
I do.
So it's fine. Congrats to you.
Thank you very much.
So let's start right into the program because we know our time is limited.
Right.
What is judicial review?
So, I mean, when you asked to do the interview, I was actually sitting and contemplating, well, what is a good definition that people could understand? And there's really no true singular definition. The way I like to think about it is judicial review is an instrument by which regular people, ordinary citizens, can challenge the decision-making process of the state and state bodies. And I think that's my understanding of it, generally speaking. And I want to emphasize, and it is emphasized throughout public law, decision-making process. It is not an appeal. It is not that you are aggrieved by, let's say, a decision of an immigration officer, a decision of a customs officer, and you are necessarily going to appeal that to a court of law. What it actually is that the court will look at the process used to arrive at that decision and determine whether or not it was lawful. And of course, the law imports certain standards in the way that public entities and public officers should make decisions. For instance, they should give you a right to be heard. It's an ancient rule, audi alteram partem. Nobody should take a decision in which they should benefit. Nemo judice in causa sua. It means that there's the rule against bias. Yes, the rule against bias. And to simplify, nobody should be a judge in his own cause, and everybody should have the right to be heard. Yes. And those are the kind of principles that you have when you talk about decision-making processes and challenging the process of making a decision.
And this is any arm of the state. It could be executive, legislative, and of course enterprises.
Well, you wouldn't necessarily in Trinidad judicial review, because we have a little dichotomy between constitutional law and judicial review. You wouldn't necessarily judicial review a legislative or so a piece of legislation per se. You would challenge it by constitutional motion. And what I mean by that is judicial review in our jurisdiction is usually reserved for the bureaucracy of the state. The state is a leviathan. It's a huge monster. It impacts people's lives in a different way. You need a passport, you go to immigration. You need a license, you go to the licensing office. You need to build something, you go to town and country. So the state takes decisions through these various agencies all the time. It affects our lives in so many different ways. How do we as a citizen standing against the state get justice? How do we hold them to account to ensure the decisions are lawful? And that's where judicial review and the beauty of judicial review comes in.
And any person can make an action for judicial review?
So usually there's a test of locus. If the decision affects you personally, meaning you made the application for your building license and permit and you refuse, you can challenge that decision. However, there are cases that could be brought in the public interest. So for instance, we've seen these regulations. Yes, there are direct interests where you may be aggrieved and you take a decision, but you could also bring something in the public interest, as long as, and the law says some very nice words, as long as you're not a busybody, as long as you're a genuine person bringing these claims. We see it a lot in environmental claims, for instance, fishermen and Friends of the Sea. They bring cases on what they perceive to be in the public interest to protect the environment. And that's another beautiful part about judicial review. It's open to ordinary citizens to challenge the state on behalf of the entire society.
But of course, you must satisfy a test.
Yes, a local test.
And those are the grounds.
Yes, there's a local test, and the court must be satisfied that you're actually acting in the public's interest, and that the matter is one that is deserving of its resources and time to determine in the public interest. In fact, what the courts go on to say is that we're not interested in about academic debates. So you can't just file a claim because, hey, I think that point of law needs to be determined at this stage, and it's an academic debate. They don't want you to condescend into academic debates. It's supposed to be practical. So there is something going on in society. You want to challenge it. Let's challenge it and let the court deal with it. And that's how you vindicate the rule of law, basically. Yeah.
And what are the grounds for bringing a judicial review proceeding?
So there are several grounds, and the Judicial Review Act sets out a number of grounds.
Yes.
Principally, you have Lord Diplock in a famous case, the GCHQ case, right? Basically said, look, you have irrationality, you have illegality, and then you have procedural unfairness. Yeah. And those are simple. Illegality is what we call the ultra vires doctrine. And what we mean by that is you're acting outside the law.
Yes.
So the statute says you have this power, and you have acted outside of that power. You are entitled to bring a judicial review to tell that decision maker, no. The law says you must do ABC. You should stick to ABC and not go on to G, onwards.
Yeah.
You also have irrationality, where it's a very high threshold, but you say that the decision maker has gone so awry. He has taken into his consideration things that really are irrelevant, right? You need a license. You should be able to drive on the road. But the decision maker says, yeah, but he goes to a lot of parties. Right?
Who are you to dictate?
You are dictated that, but the point is, it's a totally irrelevant consideration. And that is how you have this irrationality challenge to judicial review.
Yes.
You also have procedural fairness, and that's what I spoke about earlier when you talk about right to be heard and or natural justice. And that is essentially the procedural irregularity challenge. The law has moved on since Diplock in the 1980s. It has gone on now in some regards to proportionality. That's a big debate in law, whether proportionality should stand on its own as a ground of judicial review, or whether it should simply be only invoked when a constitutional right is being interfered with.
And for a layperson, proportionality, what constitutes proportionality in this instance?
Proportionality is basically, it's exactly that, without getting into the magic of different legal tests.
Yes.
What was a decision proportionate? It's often used in sanctions. So there was a famous case where Denning introduced, I would say, from my research, a concept of proportionality. A market vendor was put out of the market, and he was put out of the market. He was given a lifetime ban because he urinated in the market. And he was banned for life. And Denning said, well, yes, while the offense is egregious, does a lifetime ban fit the crime?
Yes.
That penalty seems exorbitant. And so you had that concept of proportionality seeping into the law.
Right.
In Trinidad, we're not unfamiliar with it. It's a constitutional test.
Yeah.
Whether the power, whether it's a legitimate aim that you serve. I'm sure many people have heard the Attorney General advocate proportionality all the time. Yes. He likes that test.
Yes.
So that's a ground. There's also the ground of transparency, meaning that a public authority should act in a transparent manner. One of the big ones in Trinidad is legitimate expectation. The government makes promises and representations to citizens all the time.
And you see a lot of that in public offices, where public officers would have legitimately expect to be promoted.
And that's because you could have a practice of doing things by seniority, which is a common complaint in the public service. This has been the practice. We promote via seniority, and therefore have a legitimate expectation. It could be that the public authority sets out a policy. We will judge you by ABC, and you can be entitled to this benefit, but they decide to change their policy. You would have had a legitimate expectation to use that policy and to be assessed by that policy. There's a famous Clico case where the allegation was that the government made certain representations to former policy holders. That matter went to the Privy Council. The Privy Council basically held, well, yes, there may have been a legitimate expectation, but because of these macroeconomic considerations, we're entitled to frustrate that legitimate expectation. So there's sufficient flexibility in that area of law.
Yes.
Yeah?
And you touched on legitimate expectation, because I would have noted that there is a particular case whereby the the Minister of Finance, I think you would have written a pre-action letter to the Minister of Finance because they failed to promote the chairman of
yes,
there's a
matter we actually filed a case,
yes.
So it's before the court.
Yes.
So I don't want to talk too much about it, but it is in the public media. But the point, that's just another example of a public officer having an expectation to do something and it being frustrated because the government has changed its position. And the simple way to think about it and for people to think about it so that they know if they have a right. If the government has made a promise to you, which is clear, devoid of qualification, and they have deviated from that promise, it could be a settled practice, or it could be actually put, I will act in this way, and they've deviated from that practice, then you have a cause of action in judicial review. The law recognizes that government can't be held to its own policy forever. In fact, when you change government, when you change administrations, people are entitled to adopt different policies. But what the courts will say is, well, look, if you're going to change a policy, you have to do it fairly. It may or may not involve consultation. Yeah. It should involve notice. It should have some transitory provisions to ease the harshness. But you must be changing this policy for a legitimate aim, right? You can't just be doing this to act arbitrarily. You should not frustrate my legitimate expectation unnecessarily, or you should do it in a fair manner.
Right, and okay, so someone, that's case in point.
Yeah.
Someone would have a grievance.
Yes.
They would come to an attorney. What steps, what is the procedure to start judicial review proceedings?
Right. So people need, first off, I think one of the first things, people need to be aware of their rights, and shows like yours are very helpful in that regard. So they need to understand when they may or may not be aggrieved. And the easiest way to do that, of course, is to consult a lawyer. I don't think you necessarily have to go to a specialist public law lawyer. Generally, I think all lawyers have a good understanding of the public law lexicon. So they come to you, they make their complaint. The first thing the lawyer would determine is, well, is the decision a public decision? Is it made by a public decision maker? Is it made by the government or a state arm or someone exercising public power? That's how you know if to go into judicial review. I can't judicial review a show. It's not a public body.
Yes,
you look at public bodies and you look at the decision, the quality of the decision. Is it a decision that is one that is public and has public consequences and that sort of thing? So the common ones are immigration decisions, customs decisions, town and country decisions, some decisions by RHAs, other public service decisions, generally speaking. Those are further ministerial decisions. Those are generally ones which are clothed with the necessary quality of a public nature to invoke judicial review. You do that pre-action protocol, usual along the civil train. You make an application for leave to apply for judicial review. That is because the court does not want to waste its time, and it's a filtering process.
But the first thing before you reach to that stage, you have to write a pre-action protocol letter, of course.
Pre-action protocol is always, it's part of the protocol. It's always necessary. There are circumstances where you can circumvent it because the matter is urgent and you feel that you could either bridge the time, instead of the usual 21 days, you give 7 days, or you could not issue it, but you'd have to explain to the court why you didn't issue it, because you were out of time. And one of the reasons, especially for public law practitioners, what we have to be concerned about is a time limit, which people should also understand. Generally speaking, you have a 3-month time limit from the time the decision is made. It's not like regular civil law, you have 4 years. So people who feel that their public law rights have been transgressed, they need to act quickly. And that is because it's for good administration. There's a good reason for it. For instance, if you wanted to challenge a promotion, you can't wait 4 years after someone has been promoted instead of you. They're in the position, and then you want to bring a challenge 4 years later. You have to do it quickly because you don't want someone to go along the line and a third party filling the position, and then you are now bringing a challenge to upset the entire order of the administration.
But is there, well, of course, there's a limitation period for bringing
So it's 3 months, generally speaking, but that test has been, I would say, interpreted in a generous manner. Recently, there's a case of Devant Maraj brought a claim, and the courts basically said, well, look, yes, you have to be strict with it, but there are other considerations. Is the matter in the public interest? Is anybody prejudiced by you bringing your claim late? And if so, we'll allow you to bring your claim outside the 3 months period, but you have to have good reason and all these other factors you have to satisfy.
Now, the court will make certain orders.
Yes.
Let's say the government or whoever, the public body, does not follow through on those orders. What happens? What are the consequences?
Well, any court order should be respected, first of all. It's not only, and I would go so far as to say, and there is law to support this, if an order is made against a citizen, you have to comply or you could face contempt of court. If you are aware of an order, even if you're a citizen aware of an order, you should do what you need to do to ensure that order is enforced. You can't obstruct the execution of an order.
Yeah.
That may also lead you into contempt. And similarly, like public bodies, they have a greater duty as a public body to follow orders of the court. They must respect orders of the court. And there are many cases. I remember one from India. The name escapes me right now.
Yeah.
But they actually say that the state is not like a regular litigant. The state is a virtuous litigant because it has a greater duty to ensure that the rule of law is upheld.
Yeah.
If the state wants to break the law and break court orders, then who are regular citizens to follow the law? And that really goes to the root of law and why we're a society governed by laws as opposed to men.
Yeah. Now, notably, you would have been involved in a lot of judicial review matters. If you Google search your name, you would see many matters.
by good guidance and good opportunity. And
of course,
yeah.
Of course. Now, I want to touch, I know this matter, as you said, is before the courts, or soon to be before the courts.
Yeah.
But there's a particular matter with respect to the scholarship,
yeah.
The criteria for awarding scholarships that has been quite in the public domain.
Yeah.
Could you just tell us what exactly?
Well, yes. I won't go into the merits
yes.
of it. If you'd excuse that, I won't
Certainly.
go into the merits. But what I can say, it's essentially a challenge based on legitimate expectations. The argument is very simple. Students were told that they could obtain scholarships based on certain criteria. That criteria was academic performance. Criteria has changed. Some students have already written exams. Some students have already prepared themselves in that way. The changing of the criteria to other things like extracurricular activities and whatever, that may be laudable and that may be a good policy.
Yeah.
But what about the students who would have already prepared themselves and said, look, I'm not going to do this, I'm not going to do that, I'm going to beat book.
Right, yeah.
Right?
Yeah, yeah.
And I have put myself in a position to win a scholarship. Shouldn't those students, at least up to a certain point, be given the opportunity to be assessed for scholarships on the criteria that you promised they would be assessed for? And that is essentially the thrust of the claim. It's a legitimate expectation. Yeah.
And there was another matter whereby you would have filed a pre-action protocol letter against the state with respect to import duties that funeral homes.
That's another one that's before the court.
Yes.
I think that shows the flexibility of judicial review. That's a case for the Funeral Association. Basically, the way when goods come into customs, and customs law is something that I've learned a lot.
Yeah.
My previous association with Fortis Chambers, it said Mr. Jagdev I've learned a lot of customs law there. Essentially, that's a classification issue. So what you had was goods coming in, it has to be classified for the purposes of duties, right? There's a lot of fighting as to where you're going to classify my good, right? Because obviously some duties are higher, some duties are lower. Mm-hmm. The Funeral Association, of course, is saying, well, look, this hearse is this type of car, so it should be of the lower level. The state, interested in the taxes, are saying, no, it should be classified at this because the taxes are higher. And
because,
so
because hearses now, they've changed, the models have changed, yes, so it's now look more like a SUV.
Well, you're pitching the argument for the state. I'm a little worried. But essentially,
well, that's what I'm thinking.
Yeah, but essentially that's the argument. The state is saying, look, it might be a luxury vehicle. The association, well, no, this is a special purpose. We aren't going on a date with.
But it does look like a Hummer, yeah?
Well, I'll leave that for the court to determine.
Now, Kiel, the Judicial law judgment, that has been a very, very trending matter, whereby the Court of Appeal in Trinidad would have overruled the lower court's pronouncement on that on that particular issue. But now I would have noted that you all filed a new motion that has to be lodged before the Privy Council. Yeah. To challenge the Court of Appeal decision. Yes. If you can just explain to the public the procedure in terms of how that...
it's the regular appellate process, and I want people to understand that due process of law also includes an appellate process. We filed a case before the High Court. We got a ruling, it was in our favor. The state was entitled to appeal it. It's gone to the Court of Appeal. The highest appellate body in our country is the Privy Council. the litigants in that matter are entitled to go to the Privy Council to challenge the to challenge the decision, the law, but ultimately to review the Court of Appeal's decision. And that's where we are headed now. We filed it. We've gotten a leave from the Court of Appeal. You have to get something called conditional leave. It's in these types of cases is what we call as of right. It has now gone to the Privy Council, meaning that once we satisfy certain conditions, you pay the £500, you settle the record or whatever it is, we can now argue it before the Privy Council. And ultimately, the Privy Council will determine a question that I think is very important for us as a society. It's a wider socio-political and perhaps it's... I believe in that case because it has to do with our identity. Yeah.
Because some persons may say that this particular matter is political, right? Because you are saying now that you should note, you should be guided as to what you incite, because we've seen Trinidad and Tobago is a very political country. Yeah. So you've seen where persons use their mouths with liberties, and they may incite certain actions. Yeah. And what are your thoughts on this entire one section of the society stating it's a witch hunt to expunge a law that is needed?
It's a free speech issue for me.
Yeah.
As you were saying, I was reminded of a video I heard a speech given by Mia Motley, I think last year sometime. She was addressing a Caribbean conference and she spoke about self-contempt. And she said, we in the Caribbean are imprisoned by our self-contempt because we feel we can't be the next astronaut. We can't be the next, because we're in a small island. And to me, I feel sometimes that it's almost a type of disbelief in ourselves and self-contempt, that we as a society can't maturely discuss issues and debunk opinions that are plainly wrong. The way to deal with poor speech, to put it mildly, the way to deal with offensive speech is with speech.
But then how far must one go?
Okay, yeah. I agree that you cannot use speech to incite violence, and that is clearly the law. You can't say, I can't tell you, Donawa, let's go and put a hit on somebody now. That's obviously illegal, and there are other laws to deal with it. But in terms of your opinion, I don't know if let me put it very plain. If someone is a racist, I would rather know that they are a racist, rather than you pass a law saying that they're not to say anything.
But then you have persons who have a following, and of course, they may as in the United States, we've seen Trump. He has a following. There may have been certain utterances that may be construed as racism. Yeah. So again, is how far one thinks that they can go as a free speech.
And the best place to debunk bad ideas is in the marketplace of ideas.
Right.
I have never known in the annals and history of all societies that censorship destroys bad ideas. In fact, what happens is that they fester. And when you fester bad ideas, it's even worse for society. In order to think, Ronald, you have to be able to speak. People are going to form ideas and they're going to say it in bad ways.
That influence, but then you have influence, and then somebody may act on those ideas.
And that's why we have other right-thinking members of society who are willing to come out and say, well, you're wrong. And that's how our society deals with issues. But what's worse is think about the alternative. Think about the alternative. So we suppress ideas. Even some of the worst ideas, or at a time when people thought that ideas were bad, history has shown them to be good. Communism is the perfect idea. Communism was rampant in Russia, but it led to something called the Gulag Archipelago, where hundreds of thousands of people were imprisoned and killed, and all those types of things under Stalin. But communism was well accepted, but you know what they had? They had a law saying you couldn't speak against communism, you couldn't speak against Stalin, because that was against the national good. And then what happened? That society turned out, it's history, what has happened with communism, and the amount of lives lost. And so what we have, what is the best way to deal with that, in my view? Perhaps I'm a libertarian, but the way to deal with that, in my view, is with free speech. And you can't do it. You can't do it with censorship. There's a famous quote which says that statements, society is deprived of the truth if you suppress freedom of speech, because when bad ideas come, one, you don't know what the bad idea is, but two, you're deprived of understanding and appreciating why the idea is bad, because that bad idea has to collide with truth. And people like you, people like me, people like other people in society will get on their high horses, use forums, use shows to say, well, that idea is bad, and call them out and subject it to criticism.
But then that leads now to the issue of defamation, which is another issue, because now while you are advocating, yes, we need free speech.
Well,
what about defamatory action? What about defamatory statements, slander, and all these different things that has no...
Yeah, I agree fully, but the law has put reasonable limits on free speech, which I understand. So I've spoken about inciting violence. Another one is defamation of character, which you are entitled to bring a civil suit for. But when you talk about a law that is so all-pervasive that you cannot have disaffection, you can't cause disaffection by the government, what does that mean? Yep. And I've said I am an advocate for free speech.
You advocate for free speech, but we have to continue this conversation. Of course, time is up, Kyle.
Anytime.
Time is up. However, we thank you for coming on this program to bring this discourse, because the public needs to know. So guys, this is a wrap. You have been watching Strictly Legal. Thank you to Kiel Taklalsingh, attorney at law, for coming on board with this program on judicial review. Again, see us next week. Have a good day. Goodbye.